Mr. Rossellini, do you think that in every instance in which a legal standard, no matter the degree of concreteness of the legal standard is applied to a set of facts, that the ultimate determination is a legal question?
No, Justice Alito, we don't think that. We think that under this particular statute, when that inquiry looks a lot like an admission eligibility decision or an asylum entitlement decision, but isn't one of those like we have here, that's a situation where, yes, the application of law to fact would be de novo.
My question is similar to Justice Kagan. So the definition of persecution that was applied by the IJ here is based on First Circuit precedent, is that it must add up to more than ordinary harassment, mistreatment, or suffering. You may have a set of historical facts that are undisputed, but determining whether they add up, whether the totality of those facts satisfies that standard, sure looks to me like primarily a factual question. Why is it not?
Because when courts make that decision, they are building out a body of decisional law that guides future cases. If you look at the First Circuit's decision in this case, the IJ's decision in this case, they are analogizing to cases that came before.
But that would be true in a vast majority of situations. Do you think the determination of whether of negligence is a legal standard?
No, Your Honor. We would agree that negligence would be something that's reviewed deferentially, but I think there's actually a helpful...
But every case where negligence is found or not found could be said to build out a body of precedent about whether negligence was shown. Why isn't this similar to that?
Because I think negligence, number one, the inquiry there is basically what should a person have done given the circumstances.
So they're making an interesting, it's an interesting point here. So you have, like I talked about earlier, right? We have the facts. This migrant was hit 3 times in the chest by the Sicario. That's an undisputed fact. No one's disputing that. The immigration court said, all right, I accept that as undisputed fact. I'm not contesting you, migrant, were hit 3 times in the chest by Sicario. The question for me is, even if I believe that to be true, does that amount to persecution that would warrant you receiving asylum status? And when they talk here about negligence, it's really a parallel argument. So you may have a car crash case, and there are facts in the case about what happened and who did what and so forth. But someone then has to make a decision, not just about which facts they believe to be credible or undisputed or which ones not to believe, but once they've decided what facts they believe to be true, do those amount to the legal standard for negligence? That's also a fact-finding function. So there's the kind of the core building blocks of the facts themselves, and then do they meet some legal threshold? Like for conviction, it would be, all right, we believe these facts. Do we believe they reach the threshold of proving guilt beyond a reasonable doubt? That's a call for the jury to make. The jury decides not just what facts they believe, but has it met a legal threshold? Guilt beyond a reasonable doubt. In a civil case, whether or not it's negligence. And in this case, whether or not it amounts to persecution. Would be the justices are arguing why. In terms of guilt beyond a reasonable doubt, jury call. In terms of does this amount to negligence, jury call. In terms and not subject to reversal on appeal unless it's completely irrational. So why wouldn't those standards apply here? Do these facts amount to persecution? Why should we not defer to the fact finder, in this case, the immigration court, like we do in all those other contexts?
Circumstances, the light was red, should they have braked or accelerated? People have an ordinary sense of that. I think the negligence example is a helpful one because you can contrast it with the duty of care inquiry, which, and as this court well knows, duty is traditionally for the judge, negligence is for the jury. And in the duty context, you do have to get immersed into the record to establish whether there was a duty of care. But if you ask someone on the street, hey, was there a duty of care in this circumstance or that, they're not going to be able to answer that as readily. And courts build out, again, a host of legal principles for different kinds of situations in the duty of care context. And that's what happens when courts apply the persecution standard. They're taking a term of art that's not commonly understood. They're building out these legal principles that courts can then apply and flesh out. Yes, at this kind of medium-high level of establishing.
So duty of care is a legal concept in mostly in civil negligence law. In order for you to be sued as having civil liability for having caused someone harm, you first need a duty of care that you violated. You violated a legal duty. That's what provides the foundation for your legal liability. And we all have a generalized legal duty not to unnecessarily cause other people foreseeable harm. That's what is involved in most cases. But you can have cases where the duty of care is, for example, maybe not obvious, but created by statute. And this might be, for example, the duty of care for a bar not to keep serving a patron who's already intoxicated. Often those are statutorily created duties of care. And then if you keep feeding the person drinks and they go out and they drive drunk and kill somebody, they could argue the bar has liability because they violated their duty of care to not cut that person off. That's the concept they're talking about here.
Auxiliary legal principles, as Justice Kagan was explaining, but then also refining what those auxiliary principles actually mean on the ground. What does it mean for a death threat to be sufficiently menacing to qualify as persecution or not? And again, that is why the decisions in this case, like in so many others, are looking to these prior decisions to figure out what is the mode of analysis that is applicable to these facts. And if you go to many circuits, in fact, to help their staff attorneys and law clerks have these very detailed.
Yeah, so why did the Supreme Court take this case? They don't care about this particular defendant. That's not the kind of law the Supreme Court does. They care about the underlying legal principle. So can these courts of appeals, what should be the rule for when they can reevaluate fact-finding by a lower court or a different court in a different branch? Do they just get to replicate the fact-finding of the lower court? Or do they have to defer to the lower court? Because this comes up in all kinds of appeals issues and contexts. So it's that broader legal issue that the Supreme Court's looking to clarify here, and then it would apply to many, many cases, not just this case.
Outlines explaining prior decisions that came before, so that it helps them assist their judges in making correct and efficient decisions that can be squared with the cases that came before them. But the irony in this context is that a lot of those decisions, the ones that are at least denying relief, they're not holding that the BIA's decision was correct as a matter of law. They're just saying that it was reasonable. So you have courts, you have the agency, they're all looking for guidance on this question. They're looking for precedent to use in making their determination, but they don't have a clean set of precedent to do that. They don't.
So you may be wondering, why bother with all these rules about who gets to decide what? And part of it is, like, why shouldn't the Court of Appeals get to do all their own fact-finding? Well, because we have, as a society, we have an interest in the efficiency of the process that's independent of always getting the right answer. You can't actually always guarantee the right answer in a court proceeding because the proceedings are run by humans and humans are imperfect. So you try to get as close to the right answer as often as you can. But there are other interests. Like we can't have a murder trial take 5 years, right? I mean, in theory, that would get us closer to a correct answer. Most murder trials are a day or two. So there's an interest in the efficiency of the process. There's an interest in not having redundant effort. Like, can't we just argue the facts once and have that decided? Do we have to argue it through 6 different levels of courts? So those are the reasons we have these kinds of rules. A lot of rules of procedure can seem arbitrary. Like there are courts where you have to file certain motions on a certain color of paper. And you might think to yourself, well, what's the color of the paper have to do with the merits of the legal argument? The answer is nothing. But it has to do with the process and the efficiency of the criminal justice machine itself. It makes it, the courts want it done this. Same when a court says, hey, file a motion, but it can't be more than 10 pages or 10,000 words or whatever. What's that have to do with the legal merits of the argument? Nothing, but they're putting constraints about what you're free to do so that for purposes of efficiency.
Have precedent where courts have come in and said, this is in fact the correct interpretation of persecution as a matter of law. And that is really the problem here. And again, courts are already doing the kind of inquiry that we're suggesting here under the Convention Against Torture.
Another key issue with fact-finding with the lower courts is typically it's the lower court, it's the trial court, or the base level immigration court that's doing the initial fact-finding, and they're hearing from the actual witnesses. So they're hearing people testify. So they're seeing their face, they're seeing their expressions, they're seeing their demeanor, and they're incorporating that into their assessment of credibility. The appellate courts don't have these witnesses before them. So that's another reason the appellate courts traditionally defer to the fact-finding of the initial fact-finding body who actually saw the witnesses.
In most courts of appeals, if the facts are undisputed and the sole remaining question is whether those facts demonstrate mistreatment rising to the level of torture within the meaning of CAT, they review that termination de novo, and they're doing just fine. And that's correct, because it builds out a body of precedent that courts can use effectively for future cases. And that is the kind of judicial work that under U.S. Bank we think would counsel in favor of de novo review. And it's the kind of judicial work that makes clear that this inquiry is not a finding of fact within the meaning of Section 1252.
Can I ask you a question about how the BIA reviews the IJ? Because that's a good point for you, but the government responds that the agency's decisions about how to structure internal review do not determine the standard of the review that courts of appeals should apply, which is determined by statute, constrained by the role of appellate courts, that they go on. But I want to get your clear response to the government on that point.
Certainly, Justice Kavanaugh. And again, we're not here telling you that the BIA's interpretations of these regulations dictate the meaning of the statute. But what's telling is that the regulation on which the BIA relies uses the exact same words as Section 1252b4. It says findings of fact. And the BIA has said that this exact inquiry is not a finding of fact. And on top of that, the BIA, despite recognizing that immigration judges are in the room, they're hearing the witness's testimony, they found the evidence, the BIA is still viewing that as something that it is institutionally better positioned to resolve, just like a court is.
Thank you.
Thank you, counsel. Justice Thomas? Mr. Sotomayor?
Counsel, you did not challenge below the legal standard that the First Circuit uses, right?
Not explicitly, Your Honor. We've obviously resisted the finding of persecution here.
So that now we have Sotomayor. Sotomayor sounds a little kind of breathless. Maybe it's the diabetes. Kagan sounds nasally.
Here we think that argument.
But you didn't say that they've used the wrong definition. I
Like her voice is kind of wispy, like grandmotherish.
actually don't understand why a credible death threat would not always cause suffering or harm, and the other side will respond to that. But you didn't say that. You've been arguing something quite different.
We did not make that argument explicitly before the First Circuit. I think it's fairly subsumed in the question of whether do these facts, as they are, demonstrate persecution. And again, on
I
remand.
understand the government's position. If you had challenged the standard, they would say that's a legal question that the court would have looked at. But because you didn't, you were actually arguing the facts, that these facts showed enough suffering or harm. I think that's their position.
I do think that is the government's position, but again, below, we were up against
Do you lose if I accept what the government says?
No, Your Honor, because in the First Circuit, they cabined their review entirely to deference to the BIA, and like many other courts of appeals, they have not taken the same position as the government that a question like that would be reviewed de novo.
You're saying we have to look at that question.
Correct.
We have to decide that.
Not in the first instance, but remand so that we can advance it. Maybe the government has a waiver argument. Maybe they argue that we didn't waive it because there was First Circuit precedent on point, but we need to go on bonk. We'll have that fight on remand, but it's not something this court should resolve in the first instance.
Thank you.
Justice Kagan?
Can I make sure I understand your argument about Elias Zacharias? Because I think that's I came in thinking this is a strong argument on the government's side, so I want to understand why you don't think it is. But if I look at Elias, if I look at that footnote, the court is clearly saying that we're going to provide deference here because, you know the footnote I'm talking about, right?
Yes.
I can't find. And then the question that they're providing all this substantial deference on is this. It's whether a guerrilla organization's attempt to coerce a person into performing military service necessarily constitutes persecution. So I don't get it. That seems like at least, that seems a very similar question to this one, and they're providing substantial deference.
Well, 2 points there. I think the question that Your Honor finished with of whether there's like a categorical rule that something would qualify as being on account of persecution, I don't actually think that the court deferred to the BIA in that regard. It analyzed that legal issue for itself. But the underlying question of what was in the persecutors' heads, why were they doing this, that is a classic finding of fact. And again, the statute that Elias Zacharias was analyzing, like this one, did not say...
You're saying that the only thing that Elias Zacharias deferred to was an underlying finding of fact, as opposed to the application of a legal standard to those facts?
I think that's right, Your Honor, because again, what Elias Zacharias was analyzing, and the opinion makes this clear, is that the statute makes motive central. And what the non-citizen had failed to do in that case was come forward with sufficient evidence to compel the conclusion that the motive of his alleged persecutors was on the basis of political opinion. That was the molten core of the dispute, and the court correctly viewed that as a factual issue going to state of mind, and it reviewed that deferentially.
Okay.
Justice Gorsuch, Justice Kavanaugh.
So I think you're saying Elias Zacharias was written more broadly than it needed to be, because as written, it is broader than that.
I think there are a few lines that are a little bit more broad, but again, I think that's exactly why this court has cautioned multiple times. We do not read judicial opinions like statutes. We take them in context. We look at what was the actual question presented.
If we read those lines as written, that's a problem for you.
I think it would be a problem for us. But again, we would encourage the court not to read its opinion like a statute, but read the statute here like a statute. And that's where the government.
Second different point, on pages 4 and 40 of the government's brief, as you point out in your reply, they make this, you call it concession about legal arguments. Do you have I'm going to ask them this, but do you have a sense of how that's going to apply?
I think it's going to be tricky. I mean, again, I do want to commend the government for making that concession, because that is not how many courts of appeals are viewing this issue. They are deferring to the BIA on those kinds of questions. We've cited some cases on our reply brief doing just that. So this court, again, takes.
Your point is that the government's brief is asking for something new as well?
That's correct. That's correct.
Well, we'll ask them about that.
Okay.
Thank you.
Justice Barrett, Justice Jackson.
So as I understand the history of this B4, Congress added it to the INA when it enacted ARERA in 1996. And prior to that, I understood that courts were applying deference, substantial evidence review to this asylum eligibility question. So if you're right that Congress was silent as to what is supposed to happen with asylum eligibility, I guess I'm trying to wonder whether we shouldn't believe that Congress wanted the pre-existing practice to continue.
No, Your Honor, that pre-existing practice was not, with respect, as Your Honor described. It's true that some aspects, like motive, as was at issue in Elias Zacharias, were reviewed deferentially, as they should be, as they still are today. But if you look at the actual component of the asylum eligibility inquiry that is at issue in this case, what rises to the level of persecution, that inquiry, the government has a extended string cite on page footnote 2 of its brief, and those cases are not, by and large, not addressing that issue. They're addressing other issues. They're just referring to.
All right. Do you have a corresponding string cite of cases pre this provision?
Yes, in our reply brief, forgive me, the page numbers is escaping me, but we've cited a couple of cases that go the opposite direction. And the point here is that the government asked you to grant cert in this case because they agreed with us that the courts were so confused about the appropriate standard of review as to this narrow subcomponent of the asylum eligibility determination. I think with respect to my friends, it's a little bit rich to say that confusion that is so entrenched and significant that they supported cert in this case can somehow be resolved on a snapshot consensus at a given point in time. That's just, that consensus did not exist.
All right, one more question. Going to the kind of overall thrust of your argument, it would be to enable courts to consider this de novo and particularly and possibly override the BIA's determinations. And I guess I'm wondering how that's consistent with what we understand the general thrust of Congress's amendments and the thrust of ARERA to be, which was really to limit the court's ability to override the agency in this context. So it seems like this would be a little discordant with what Congress was trying to do here, right?
No, Your Honor. Point number one, asylum has actually been kind of like singled out for special treatment by Congress. If you look at Section 1252A, even the discretionary determination about whether to grant asylum, that's judicial review over that determination has been preserved, even as Congress stripped away judicial review of most other discretionary determinations. And I think what that tells you is that even as Congress is of course, was limiting judicial review in many respects. It viewed asylum as different and something that needed to be preserved in significant part. And I would also just come back to the fact that we're not vouching for a change here. We're saying that Congress crystallized in Section 1252b4 what had already been the case, is that a determination about whether undisputed facts legally qualifies as persecution is not a finding of fact. Those words, they were in place before era, they're in place now, and the plain meaning of those words does not encompass this determination.
Thank you.
Thank you, counsel. Mr. Dos Santos?
All right, before I jump into the Trump response, let me hit these super chats. James Marino, $10. Thank you very much, James. Says, blatant Democrat process lawfare. New York Attorney General admits no donor complaints, but issued subpoena for all donor information for bullshit excuse of misleading solicitations to donors by pro-life organizations. This would be the abortion centers in Jersey, right? They get donations, people give contributions. Normally those would not be public. But of course, the very pro-abortion blue state of New Jersey was trying to get a hold of those lists, presumably to hassle, intimidate, or otherwise punish the people who made the donations to the pro-life center. I believe that got checked, but that's not a topic of the law I cover very closely. Cajun Ranger says they should put closed captioning along with who the speaker is along the bottom of their videos. Yeah, some places do that, but this just happened yesterday. I don't think anyone has put that production effort into it. You don't usually see that in real time.